Voilà, chers collègues, on va recommencer notre...
So, colleagues, shall we then start our exchange of views on human rights and workers in Sri Lanka? We know the situation of human rights in Sri Lanka is problematical. This is why we are about to discuss families, lawyers, and the repression is continuing of any peaceful demonstrations. There have been problems during the pandemic, and forced labor is increasing. Factories are staying open despite confinement, and workers have been deprived of their income and social security. We are here to debate the situation in the country, and I'd like to welcome Madam Ambika Satkunanathan, lawyer of human rights and former commissioner of the Sri Lanka Committee on Human Rights, and Madam Simran Singh, director of the National Bureau of the ILO in Sri Lanka, also well placed to tell us about the situation of the rights of workers. Ms. Pratt's unit head of the European Commission is also here. We have Nicola Vaimi, Councillor for Trade and Sustainable Development in the European Commission, who will not be making a presentation but will be able to answer any questions put to him directly. So 8 minutes to our guests each. Ambika Satkunanathan, you have the floor, and you have 8 minutes, madam.
Good morning, honourable members of the European Parliament. Thank you for inviting me to speak at this hearing. I will focus on the general human rights situation and particular aspects that are of interest to the EU. Successive Sri Lankan governments, including the government that came to power in 2015, failed to deal with accountability for human rights violations, especially war-related violations, and thereby entrenched impunity. For instance, police brutality and torture are systemic in Sri Lanka. Sri Lanka's deep-seated accountability problem is demonstrated by the normalization of elected and appointed public officials breaking and abusing the law with impunity. The government's promises to advance accountability appear disingenuous in light of their actions. For instance, illustrated by the failure to hold anyone accountable for the many emblematic cases of human rights violations, such as the killing of 5 young men in Trincomalee in the Eastern Province in 2006. Impunity has therefore become the permanent normal in Sri Lanka. Successive governments also refuse to acknowledge and address the majoritarian nature of the Sri Lankan state, which is driven by Sinhala Buddhist nationalism and normalizes the discrimination of other ethno-religious communities. This can be attributed to the fear of even relatively liberal governments of losing their support base and being seen as too accommodating of the demands of the non-majority communities. The current government has authoritarian tendencies and has consistently shown contempt for the rule of law. It makes no effort to even pretend to adopt an inclusive and transparent approach to public policy making and governance. Instead, it reaffirms the majoritarian nature of the state at the macro and micro levels at every opportunity. Sinhala Buddhist nationalism and militarization are the 2 pillars of the president's ideology that drive his decision-making and action. The North and the East are occupied by the military, and the politics of hate fueled by Sinhala Buddhist nationalism targets Tamils and Muslims who are subject to ethno-religious profiling of different forms. This gives rise to discrimination and marginalization. All this is aided by a historically abusive and unaccountable national security regime, which has been rapidly expanding since November 2019. Two structures outside the formal governance processes play a role in giving effect to the two pillars of the president's ideology. One is the Presidential Task Force on Archaeological Heritage Management in the Eastern Province, which has the membership of Buddhist clergy and is headed by a Buddhist monk. The other is the Presidential Task Force on One Country, One Law, headed by Gnanasara Thera, a Buddhist monk who was found guilty of contempt of court and has incited hate and violence against Muslims for many years. The Task Force on Archaeological Heritage Management enables the takeover of land in the north and east by the Archaeological Department under the pretext of reclaiming Buddhist sites, often aided by the military. This is an example of the law and legal processes being instrumentalized to effect demographic change in Tamil or Muslim majority regions, and is likely done with the aim of reducing the number of Tamils and Muslim representatives who will be elected to parliament from these regions. This will reduce then the numbers of Tamil and Muslim voices in parliament. Civic space is shrinking, and informal and extra-legal processes are used to curtail the activities of civil society organizations. Human rights activists, journalists, and dissenters in the country are at risk of state reprisals, including arbitrary arrests and detention. The threat of repressive new law to control civil society organizations is ever present. In this context, civil society, families of the disappeared, families of persons detained under the Prevention of Terrorism Act, journalists who report on issues such as militarization and state takeover of private land in Tamil and Muslim areas, and former combatants are subject to surveillance, intimidation, and threats. During the pandemic, the government used health regulations to restrict the right to assembly and association of civil society, as well as to prevent the efforts of victims, such as the families of the disappeared, to memorialize. The same rules, however, were not applied equally to government events, which continued without interruption. Due to the war on drugs, extrajudicial killings, as well as a large number of arrests and imprisonment of persons who use drugs, has been noted. Compulsory drug rehabilitation, which violates international human rights standards and is contrary to the UN Common Position on Drugs and the UN Joint Statements on Compulsory Drug Rehabilitation, is still legal in Sri Lanka. People detained in drug treatment centers, some of which are managed by the Sri Lanka Army, suffer physical and psychological violence, inhuman conditions of detention, and lack of evidence-based treatment. The Prevention of Terrorism Act continues to be weaponized against Tamils, Muslims, dissenters, and civil society. For instance, civil society organizations, usually from the north, are being summoned or visited by the Terrorism Investigation Division for inquiry related to their financial remittances and work. Prima facie, the summons and visits do not seem to be based on evidence or reasonable suspicion of the organizations having received funds from illegal entities or using it for illegal activities. Rather, the intent appears to be to intimidate, harass, and curtail their activities. Another example is the de-radicalization from holding violent extremist religious ideology regulations issued in March 2021. The regulations create a new predictive style of offense based on a broad legal definition that enables the arrest and detention of citizens contrary to the procedures set out by Sri Lankan law and international human rights standards. The regulations allow investigations to commence after an arrest and therefore deprive persons of knowing the reason for their arrest. The subjective determination of what is deemed an offense risks the decision being influenced by personal prejudice and unconscious bias. The regulations also violate the right to a fair trial because they allow a person to be deemed guilty and sent to rehabilitation for up to 2 years without trial, a decision made solely on the recommendation of Sri Lanka's Attorney General. There is no mention of the criteria by which the decision to send a person to rehabilitation is made, nor is there information on the contents of the rehabilitation program. Finally, it should be noted that the current government uses interstate rivalries, such as that with China, to silence or undermine the efforts of states that call for accountability for human rights violations. At the same time, it also craves the validation of the West, illustrated by its actions. In this context, it is important to note that any action the government has taken to date in relation to human rights issues, however minimal, is only due to external pressure and not because of praise or financial support. Such critical pressure points include the European Union's GSP Plus trade privileges and the UN Human Rights Council resolutions. I'd like to end with 3 quick recommendations. One is using the leverage of the GSP Plus privileges that they provide to strongly advocate for the government's adherence to its international human rights obligations, particularly in relation to the Abusive and Human Rights Deficient Prevention of Terrorism Act. Number 2, support the evidence-gathering mechanism established within the Office of the UN High Commissioner for Human Rights, including through the provision of required financial resources. Finally, support efforts to use universal jurisdiction to hold those responsible for human rights violations accountable. Thank you very much, and I'll be happy to answer any questions.
Thank you.